under Uniform Commercial Code 440.2511 by tender of payment 2 and 3.
It's not applicable to this case.
And could you tell me why, Your Honor?
Because the UCC doesn't apply to this circumstance.
How you doing, Your Honor?
What's your name, sir? What is the claim in this case?
Judge, this is a non-payment of rent action with a money judgment being requested as well. I'm showing that rent is due in the amount of $1,588, court costs of $217 for a total rent retained of $1,805.
And sir,
Yes.
how do you intend upon paying this?
So, Your Honor, I actually tendered payment to Group 5 Management on November 3rd. And my form of payment was refused.
Was what?
My form of payment, she refused payment.
What was your form of payment?
A cashier's check. I actually have the voided check here. And I'm asking for...
Okay, now this just got interesting. The tenant is claiming he actually tried to pay the rent. And not only that, he says the landlord refused the payment. In eviction court, that can become a huge issue because judges often want to know whether the tenant genuinely attempted to cure the default. But listen carefully. The entire case is about what kind of payment was offered. Cashier's check? Counter check? Certified funds? That distinction sounds boring until it suddenly decides whether someone keeps their apartment or not.
I believe my client or the client was supposed to be on. My understanding was that it wasn't a cashier's check. It was a counter or a check. And the reason it would have been refused was because he's had more than 3 checks come back as insufficient funds. But I would ask if I don't see if he's on here, Judge.
From Randolph Court or Group 5 on the Zoom? We don't have anybody checked in.
We don't.
Email.
Judge.
Hang on, listen, he has an email saying about the refusal. Well, it's a text message screenshot.
Yes, it's an email. I actually screenshotted it.
And it says from somebody with the last name of Aslam, ASLAM, indicating that they received a rent check in the sum of $1,238, which the check that he showed me was in that, in the form of an over-the-counter check. However, must be certified funds. And then, second page, as the system will not accept this, maybe. But
Yeah, Judge, my notes on the ledger show counter check, which is a check that's not, it's one of the ones they give you from the bank. And so again, that's the position I was taking anyways, it was refused.
So, sir,
Yes.
is there a reason why you can't get certified funds to the landlord?
Well, they actually accepted December's rent from the same check, Your Honor, from my bank.
Okay, but if...
Well, because it costs. And my defense is that under Uniform Commercial Code 440.2511, by tender of payment, 2 and 3.
It's not applicable to this case.
And could you tell me why, Your Honor?
Because the UCC doesn't apply to this circumstance.
I'm sorry?
The UCC doesn't apply to this circumstance.
It's a commercial transaction, Your Honor.
The UCC does not apply.
Okay. So where could I find this at that says that this isn't a commercial transaction?
That would be your assertion. I'm telling you it doesn't apply to this.
Just for my understanding that the Uniform Commercial Code governs all commercial transactions in commerce. And so based off of this law, tender of payment is why my defense is that once the tender of payment was refused, at that time, the charge or the total amount was charged.
Even if you were to do that analysis, you can't then have unjust.
And here comes the legal rabbit hole. The tenant is trying to use the Uniform Commercial Code, something usually connected to business transactions and negotiable instruments, as a defense against eviction. The judge immediately shuts it down because housing court is focused less on abstract commercial theory and more on a very practical question. Was the rent properly paid or not? But then the judge drops a key line. You can't have the apartment and not pay. That's the court pulling the conversation back to reality after a deep dive into legal jargon. Also, you can feel the frustration building on both sides here. One side thinks the law is crystal clear. The other thinks the judge is ignoring the law entirely. That tension is what makes hearings like this explode online.
The extra $700, $600, I'm not sure where it's coming from. But if they accepted the rent payment and from my bank in December, I'm sure, I don't know why they wouldn't accept it now. They refused November and then
Okay.
they accepted December.
Sir,
Yes.
I'm asking a very simple question.
Yeah.
Are you going to tender certified funds to them in the amount of 1805?
I will surrender. I will submit funds.
Certified funds to them.
I plan to, it costs me to do certified. So I would,
As does
I would
the
like,
NSF transactions that they've had in the past. So that is my question to you. Are you going to submit certified funds
I'll submit certified funds.
in the amount of 1805?
I like to debate that amount because I'm not sure where that amount's coming from. My rent is $1,238. In court costs, I'm not sure what the other $600.
All right, here's what I'm going to do.
Yeah.
Defendant to submit.
This is actually a very strategic move by the judge. Instead of debating every single legal theory in the moment, the court separates the undisputed amount from the disputed charges. In plain English, the judge is basically saying, pay the part everyone agrees you owe first. Then we can argue about the rest later. That's a huge moment because it shifts the hearing from philosophical arguments to immediate consequences. If the tenant doesn't bring certified funds by the next hearing, the judge already warned what happens next. Full judgment, more rent added, and potentially losing the case entirely. And honestly, that final exchange about missing work, that's the moment this stops feeling like internet courtroom entertainment and starts feeling very real.
Time that I'm coming here, I'm having to take off of work. And
Sir, I cannot help that.
I mean, is there a way that we can set a different date?
That is my next day.
Okay.
Thank